minutes remaining. I should also advise I have to leave to a different engagement. I apologize. That may mean I'm simply deputizing Ms. Grant to serve the timekeeper function at some point in the afternoon. Thank you.
Mr. Commissioner, I had a couple of points I thought would help clarify just before I continue. One relates to a question from Mr. Harrison. Yeah, it just in regards to inspector status, the one key difference or one key point by removing inspector status, staff members, Habitat staff members would not be able to take action or direct action to stop a violation. That's the key difference by taking the status away. In other words, if a person with inspector officer status encounters a violation that is continuing to occur, they can take that direction, direct it to stop. A guardian will not be able to do that. And the second point I had was, and I obtained that, I got a copy of the Fisheries Act from Mr. Bissett and looked up the inspector on that. The second point related to when I was describing the experts on fish habitat, I focused on the water, but it's also very important to understand that the vegetation along the banks of the river is the riparian zone, and it is called, is also deemed fish habitat. There is case law that it determines that. So it's very important. That's something, that's a common thing that we come across is people say, well, I didn't do anything in the water. Well, you can destroy the vegetation on the bank, and that is destroying fish habitat as well. So in those cases where that occurs, we often rely on our habitat experts or experts as well.
Thank you for those clarifications. Mr. Harrison, again, for the record. Mr. Nelson, one thing you said this morning, and I just want to get your clarification on, is you spoke about occurrences. And potentially, actually, let me, Mr. Registrar, can you bring up the PPR in paragraph 74 of the PPR? But I'll continue my question. You spoke about occurrences this morning, and included in that, you said that basically anything brought to the attention, this is my understanding of what you said, was anything brought to the attention of your staff, including calls from the public, would go into what's called an occurrence. It would be tracked as an occurrence. Is that correct?
It should be received and entered in our data violation system as an occurrence.
So, just looking at this chart, I mean, we see in the year 2000 there was 1,500, over 1,500 occurrences, and in 2010 there was 360. If occurrences include, you know, members of the public and just sort of referrals of those nature, it's difficult for me to understand the discrepancy between those two numbers or the differences. Do you have any insight into why there's such a difference?
Well, I don't know what percentage of these are reported by the public, but as I stated earlier, a lot of our occurrences are generated by officers going out and by staff members going out.
So, thank you for that. So what you're saying is the fact that fisheries officers or guardians being out in the field less has resulted in less occurrences being tracked? Is that correct?
It's one factor, yes.
Thank you. Mr. Steele, do you have something to comment on?
Just to perhaps clarify it, I think in the heading it refers to habitat occurrences responded to by CNP, so I'm thinking that it may not be the full number of occurrences.
You have poked a remarkable hole in my line of questioning, and thank you for pointing that out, and you are right. My question was, I withdraw my question because you are right. I apologize for that. Ms. Bombardier, I was wondering, and maybe I'll change my question as well, but do you have a similar sense of occurrences, both the number that have been tracked and responded upon with respect to the Department of Environment?
I have some numbers based on previous discussion with my staff in Pacific and Yukon region for last fiscal year. I believe we got in the range of 2,500 occurrence or notifications under the Fisheries Act 36.3. And of those, about 10% led to actual on-site inspections and then enforcement.
This is a question, I guess, for each of you, and so no one in particular. But I believe it was you, Mr. Steele, who mentioned that, in your view, often fines are too low. and excuse me if I put words in the wrong mouth, but there has been evidence in the last 2 days that generally there's a feeling that fines are potentially too low for effective deterrence. And I guess I'm not thinking about maximum fines, but more about fines actually imposed. Does anyone have opinions or comments as to the level of deterrence from the sufficiency of fines imposed when prosecutions do take place?
In my experience, sometimes fines are perhaps felt too low by the officers, maybe because they didn't do a good enough job with the prosecutor to present all the information. If good impact statements are presented to the courts and good evidence, generally you'll get much more favorable fines. It's a matter of educating a lot of times the courts about the importance of fish habitat. And in my experience, if you emphasize on that and focus on that, fines will be higher.
I would agree with that. Educating the courts in terms of the environmental impacts of violations is a key factor. Environment Canada has been, as proposed, there's actually a new legislation that came into force, I believe in 2009, Environmental Enforcement Act, which amend 9 other acts, including the CEPA, Canadian Environmental Protection Act. It doesn't amend the Fisheries Act, but it does provide an administrative monetary scheme, administrative penalty monetary scheme, actually through another act, the Environmental Violation Administrative Monetary Penalty Act. So there will be a scheme of penalties for individual offenders and corporations. And that will take into account the economic benefit of violations.
I've circulated a couple of documents, one which will be contentious and one less so. And the first is and this is the less contentious one, I hope, but Mr. Nelson, yesterday in your evidence you mentioned a direction or the equivalent of from Deputy Minister Larry Murray with respect to EPMP and the notion that there was a direction to not focus on habitat enforcement. And I've circulated this document. Is that the document you were referencing in that testimony?
The one that has a picture on the front?
That's correct.
Yes. Yes, this is the one one of the items I was referring to, yes.
So, sorry, there are additional items that you were referring to? Was there any internal memorandum of any kind from Deputy Minister Murray that gave the direction of which I speak?
There may have been, but I know there was some directive from Paul Coulerier as well, internally.
Okay, thank you. And I would like to mark this as an exhibit, if that is appropriate.
And there isn't an objection, but there's no registrar at this very moment. I think it makes sense. It was referred to by the witness, and I don't know, Mr. Bissett, if you can assign the number, or if we can simply await.
Exhibit 694.
Thank you.
Thank you.
Well, I don't think it can be 694. I think we're at 715. Oh, Mr. Registrar.
It's probably the only 2 minutes he's ever been out of the courtroom, and of course we picked that moment.
While we're doing this,
716.
I'd just like to make a point of clarification. This is a document from an intranet site, and the link to this particular document is in CAN 128180.
Next, I'd like to, excuse me.
I'm not yet objecting, but I'm going to raise that Mr. Harrison has 5 minutes remaining.
Thank you. I only have 2 more matters that I want to get to. The first is in the toolkit that's been mentioned, it's quite clear that both the DFO and the Department of the Environment has put prosecutions at the, as a last resort. I think that's been stated in evidence. I represent persons who are concerned about ongoing destruction of fish habitat generally, and in the Fraser River Basin in particular. And many of my clients, if not all of them, believe that the lack of enforcement is among the primary causes of the loss of habitat. My question to you is there any, first, is there a either unwritten or written policy with respect to private prosecutions under the Fisheries Act? Do you, despite your toolkit and putting enforcement at the bottom, do you feel that it's appropriate for members of the public to engage in a private prosecution for violations of the Fisheries Act? And I would just like to put a tiny bit of context and also say that if you are aware that the Fisheries Act does have a provision with respect to fine splitting, which from our point of view, and it has been said that this is actually an indirect encouragement of private prosecutions. But my original question stands. With respect to the toolkit and DOE and DFO's view on putting enforcement or prosecutions at the bottom of the list, do you feel it would be appropriate for other members of the public to take over that role if we believe that the acts are being violated chronically and repeatedly?
Well, I'm not sure that I could speak for a DFO position on that issue. I'm not sure that I agree with the description of prosecution being put on the bottom of the list in terms of importance or priority. I think it's better characterized as saying that we use, prosecution is one of the options in the toolkit, and that it's the department's policy to examine other options short of prosecution, but it's not ruling out prosecution by any means, or saying that having it at the bottom of the list means it's a less important tool than any others.
Well, I guess on that note, can you tell me how many prosecutions were brought in the past year, let's say, and how many convictions were obtained?
Not off the top of my head, but I think the numbers are
Under
in
10?
the documentation.
And are they under 10?
Most likely, yes. Yeah.
So if there was no explicit policy to rely on prosecutions as a last resort, I would say that there's been clear evidence that this is a preference. And in fact, I would say that there's a number of policies reference that preference. Do you agree with that?
I would agree with that, but with the condition that the preference is to use other options if feasible and if appropriate under the circumstances. But again, it doesn't rule out prosecution. It's certainly one of the tools in the toolbox, and the expectation is that it would be used in appropriate circumstances.
I'd say on it that I'm also concerned as a citizen as well as a fishery officer with habitat damage. But as far as prosecutions, it's if we were to go to the letter of the law and charge everybody for every tree that they cut down in a riparian zone, or spilling a cup of fuel when they're fueling up their boat, a cup of fuel can look like a massive oil slick, and technically it's a violation. So you've got to really assess the size and the impact of it. You have to look at every case as, is it in the public interest as well? If you were to fill the courtrooms with all kinds of habitat violations and bog the system down, I don't think that is the answer either. I think what we have to do is do a better job of using the full range of our tools, including the education and stewardship part, and relying and working with the environmental groups as well as all user groups to better educate the public. And I fully accept other groups holding us accountable and responsible as an agency because of the job we have to do. As far as this section that would allow the public to prosecute, it is there, and I don't know that it's been used very often. It's and there is. I'm aware of the provision that half the fine money generated from any outcome could go to that person that lays the violation. Is it good or bad? I guess it's up to the public to decide whether they should do that or not. But if we saw a large increase in that, I think we would have to pay more attention to it and decide what we have to do about it.
I want to pick up on something. Are we running near the end?
Well, we are at the point, and if we were to hold to the plan of completing this afternoon, we will need to hold to those estimates, I'm afraid.
So I will finish up with this question. I wanted to pick up on something you said in your response, and you said, you know, we obviously would want to avoid flooding the courts with every cup of gas spilt and grass clippings went out there. But if there was chronic, repeated violations of the Fisheries Act and chronic non-enforcement by DFO and DOE, in all of your views, is this an appropriate way, is this an appropriate time for the public to come in and bring private prosecutions? And related, is there or are there any policies, either written or unwritten, with respect to private prosecutions brought under the Fisheries Act and how ministries or departments will respond?
There's no policy that I'm aware of in DFO that reflects that public prosecution section.
I'm not sure I would agree with the statement that there's no enforcement under the Fisheries Act, but to answer your question, it's no, I'm not aware either of a policy in Environment Canada that talks to private prosecutions.
And I'm not aware of any such policy either.
Okay, based on Mr. Martlet's warning, I will leave my questions there. Thank you very much.
Thank you, Mr. Commissioner. I have Mr. Rosenblum at 45 minutes.
Thank you very much. Panel, my name is Don Rosenblum. I appear on behalf of Area D, Gillnet, and Area B, Sainer. Thank you for answering my questions. I want to focus a good part of my cross-examination on one issue and one issue alone, and that relates to budgetary restrictions that we're all facing down, or you're facing down, and how it impacts upon the public interest. Mr. Nelson, this morning, in response, I believe, to Mr. Taylor, you said in part that in terms of monitoring and enforcement of the Act, that expectations continue to increase and ability to deliver continues to fall. You remember saying something of that sort?
Yes.
Now, focusing on that predicament, if I can describe it as a predicament, I've sat here for 2 days and I have, as the rest of us have, heard testimony regarding revision of protocols, new flow charts, colored flow charts, arrows here and there. Would you not agree with me that unless we solve the paramount issue of funding to your department to carry out the responsibilities under the Act, all the rest of your initiative, quite frankly, is window dressing? Do you agree with that?
I think all the measures we take help us to try and achieve our goal. The fact that budgets are reducing and appear to be reducing to a fair bit over the next year or after the next year, we're going to only be able to do a lot less.
So, and I want to make something very clear. I'm not faulting anybody in this room, and I'm certainly not faulting you as the three of you in terms of your position. But as I sit here and listen to the efforts that you're making in terms of what I'll call new schematics, in terms of monitoring, in terms of enforcement and so on, are we not, in fact, left with the dilemma that unless there is an infusion of capital into the department for purposes of discharging your statutory responsibilities, we aren't going very far in terms of improving the situation?
I would say that's a fair statement.
Thank you. I only invite comment if anybody wishes to disagree with what has been said by Mr. Nelson. Hearing nothing, let me carry on. In terms of the budgetary issues, I heard at one point testimony, and forgive me, I don't recall which of you spoke of this, that there would be, I believe this fiscal year, a 1.5% salary increase that's got to be embedded within the budget. Do I have that correctly?
That's correct.
And that is indeed obviously a collective agreement requirement.
Yes.
And did I also understand from the testimony that the Treasury Board is expecting you to meet, obviously, those contractual obligations without, in fact, increasing budget to accommodate for that negotiated settlement?
That's my understanding.
And can I assume from that as a result, that 1.5% that is obviously as a priority allocated for salary increase is at the expense of the rest of the budget, and in particular operational side of budget?
It could come from not filling vacancies, overtime, or operating money.
We have heard evidence some time ago from a Dr. Riddell, who's obviously well known to most of you in terms of fishery experience and work with DFO, and he spoke about the budgetary restrictions, and he made the point that when there is, for example, a 5% cut in budget as dictated by Treasury Board, that 5% is in fact reduced down to a 15 or 20% reduction in the operational side of DFO, because they obviously, you can't intrude into what are collective agreement clauses, correct?
I'm not sure I follow that.
Okay, well, sorry, I may not have done a very good job of basically what Dr. Riddell said, to the best of my, and I actually could refer you to the transcript, but we don't have much money, is that when there is in the case of this current fiscal year, a 5% reduction in overall DFO budget, because the salary component of budget cannot be tampered with because of collective agreement, that it means that there is in fact a far greater than 5% reduction in the operational side of budget.
I think I get your question now. Yes, if you have a 5% salary reduction, either you don't take it from keeping positions vacant to shore it up, it would have to come from other sources, overtime and operating funds. But perhaps Mr. Steele would like to.
Yes, Mr. Steele.
I think, I'm not sure about the percentages, if it's 15 or 20%, but generally speaking, if a salary increase like that of 5% had to be taken strictly from operating money, because there's no flexibility to take it from your salary budget. If you're fully staffed, people have to be paid according to contracts. So if there's no flexibility to take that 5% from your salary budget, it would necessarily have to come from as Mr. Nelson said, either overtime or operations, and the impact on operations would most likely be higher, whether it be 15 or 20, I'm not sure, but it would be more than 5%, most likely.
Right,
Yeah.
and well, we're left with evidence from Dr. Riddell in terms of his estimate of 15 to 20%, but putting that aside for a moment, what I'm hearing today with and yesterday in terms of this 1.5% increase in salary, which has also got to be accommodated for in this budget, is that there is in fact a further challenge to the operational side of budget by the fact that there's an overall 5% reduction in budget, but also a legal commitment under the collective agreement to increase salaries by 1.5%. Do you agree?
I agree with the 1.5%. That's a given for our program. For the rest of the department, and it's government-wide. It's an issue government-wide. It's over a 3-year period that negotiated settlements at 1.5% per year. So I think we're into year 2 now, I believe, of that 3-year period. The 5% reduction that you refer to, I'm not so sure about what that's referring to.
Well, there's been evidence given by your Deputy Minister, Ms. Dansereau, early on in these proceedings last year, speaking to the fact that it was notice given to her that for this upcoming fiscal year that just commenced, that as I understood it, DFO was facing down a 5% reduction. You understand that, sir?
Yes, I do.
Yes. Now, recognizing that the budgetary restrictions are impairing the effectiveness of the monitoring and enforcement of your branch, and you would all agree with that principle, would you not, that statement? You're shaking your head in the affirmative,
Yes.
Mr. Steele?
Yes, I would.
Yes. Accepting that for a moment, what can the Canadian public, with these circumstances, have any confidence that the Department of Fisheries and Environment Canada will be able to effectively carry out their statutory obligations over the next couple of years? What light is there at the end of the tunnel if the status quo in funding remains for the next few years? Mr. Steele.
Well, as far as lights at the end of the tunnel, I'm not quite sure what form that might take. There's always possibilities of decisions to reallocate internally within the department. The other option, of course, in normal times would be submissions for funding from the centre of government, from Treasury Board, etc. Now, given the current fiscal climate, it appears as though that latter option is probably not all that likely. That's what we're being told, at least. So, given those circumstances, we need to try to make most effective use of resources that we do have. If there's assuming no internal reallocation or prospects of new money, then the options available to us are to try to make best use of the resources that are available, make sure that we're eliminating any unnecessary expenses, that we're looking at new ways of doing business to the extent that we can, use of new technologies, that kind of things, and to try to maintain as best we can the effective delivery of the program. That's basically the options that we have available to us.
You're facing down a real predicament, aren't you?
There's serious challenges in terms of budget levels, yes.
Mr. Carter, your predecessor who testified on Wednesday of this week, spoke of sleepless nights. Do both of you, and I'm looking first to you, Mr. Steele, and then to the other witnesses, does this lead to sleepless nights, that the public interest is not being properly protected in light of these circumstances?
Well, I think that might over-dramatize it slightly. I've had some sleepless nights since I got here, but I attributed it more to the time change than anything else. But
well, I wasn't speaking of sleepless nights since you arrived in Vancouver.
Right.
I'm speaking of the day-to-day responsibilities that you're empowered to discharge under the Fisheries Act.
There are concerns, yes, for anyone, I think, at the management level. There's stress involved in that, and yes, I think everybody involved in the program that wants to ensure that the program is delivered effectively has concerns about budget issues in these times, yes.
Your response, Mr. Nelson?
Yes. Yes, it's a challenging job. I have had sleepless nights wondering about how we're going to be able to do this. To say anything else wouldn't be right. I'm concerned about the load that is placed on our field staff, particularly. The field technicians, the fishery officers who are out there, who are the face meeting the public, and have to answer these questions to the public, and carry on and do their job, knowing what's around the corner is likely more cuts.
Thank you. Madame Bardier?
What I can say for Environment Canada is we have been fortunate to have increased funding since 2007. So our situation has been the opposite in terms of additional funding provided specifically to the enforcement branch and support groups within Environment Canada to help us do our job better. So we've increased our capacity and we've increased our geographical coverage. Not to the same level as DFO, obviously, but there's been an improvement there.
We have heard evidence over this week that this region, has not sought increased funding for monitoring, and I believe their evidence included enforcement. Could I ask you, Mr. Nelson, have you fought the battle with the region to influence the region to seek from the national office, from DFO, an increase in budget because of the critical situation that you've been testifying about?
Yes, I have raised it with a number of senior staff.
But to no avail.
Not yet.
Thank you. Now, also in the PPR for this topic, PPR number 9, it refers to the Commissioner of the Environment and Sustainable Development Report, the CESD of 2009. It's found at page 44 of the PPR. And on the fourth line down, the fourth line downward, it says, in brief, the 2009 CESD report found in part as follows. Fisheries and Oceans Canada and Environment Canada cannot demonstrate that fish habitat is being adequately protected as the Fishery Act requires. Let me stop there. Hearing you in the last 2 days, and in particular in your response to my questions this afternoon, can I assume that what was said there in that report in 2009 presumably still has application today?
Yes.
Thank you.
Can I just respond to that? There's a specific recommendation, I believe, to the effect that Environment Canada should develop a risk-based approach to Fisheries Act pollution prevention, and we've been working on that. Our partners in the department, strategic policy branch, has worked on a regulatory accountability framework for the activities of Environment Canada under the Fisheries Act to make sure that we are aligned to meet the desired results of the Fisheries Act.
Speaking of Environment Canada, in your will say, Madame Bombardier, if you would go to page 1 of that document, and it's the practice of this Commission Council not to file these will says. So I would like to just refer you to one paragraph and then ask for your comment. Are the will says, can they possibly be put to be on the screen, even though I'm not tendering them as an evidence? Or I'm happy to read it out, and then if you want it on the screen, we'll discuss it with Commission Council. Under responsibilities for Section 35 and 36 of the Fisheries Act, the bullet, there it goes, mid-page. Dr. Bombardier, and I'm sorry, you are a doctor, and I apologize, I haven't been referring to you as a doctor.
Ms. Bombardier is fine, don't worry.
Thank you. Dr. Bombardier will comment on the current state of communications between EC's Environmental Enforcement Director and DFO's with respect to enforcement Section 36 of the Fishery Act. Then it goes down to the next heading, common habitat violations. Dr. Bombardier will describe how most of the work done by enforcement officers in relation to Section 36 of the Fisheries Act touches directly or indirectly on Fraser River tributaries. Current priority areas are sewage, stormwater, non-point sources, train, vehicles, agriculture, discharges from shipyards, groundwater from contaminated sites, non-regulated mining sites, spills, fish kills, fishing lodges, fish processing plants, and the cement industry. What I want to ask you is what seems surprisingly ignored in this paragraph is the agriculture industry, fish farming. Do I have that correctly, that it's not stated there as a priority, or am I missing something?
By fish farming, you mean the fish processing plants?
No.
What exactly?
I'm speaking of the actual farms and the issues, environmental issues that relate to the farms, not to the fish packing.
Those farms, the activities of those farms, PMRA, Health Canada has key jurisdiction in terms of the use of pesticides for the protection of fish in those fish farms. So the main department responsible for aquaculture activity is PMRA, but we work in close collaboration with them with regards to our responsibilities under 36.3.
Well, I may not have a complete grasp of this, but I thought the provincial powers have been handed over to the federal government in light of the litigation. Have I misunderstood? In other words, are you saying even as of now, the Environment Canada will not have responsibility for environmental enforcement at the fish farms?
We do. We do have responsibilities for pollution prevention in the aquaculture industry. Now in BC, I believe there's the jurisdiction on fish farms and the licensing of those activities, and perhaps my colleagues from DFO can better talk to that. It's not related to pollution per se, it's more the activities of the farms.
Well, again, I may not be grasping something, but when I have directed your attention to this habitat violation issue and the listing of current priority areas, why is the agriculture industry and the farms themselves not on the priority list?
It's something that we will react to if we get a complaint, but it's not. We're not doing proactive. What we call a priority is where we are very proactive.
And can you tell us why you're not being proactive?
That's mainly because of the role of Health Canada in that particular sector. And we work very closely with them, and we respond to complaints should there be a potential violation under 36.3. So the key legislation is the Pest Control Products Act that regulate that sector at the federal level.
So does Health Canada have inspectors doing enforcement at the farm locations?
But that's their responsibility, yes.
And are they doing it to the best of your knowledge?
I believe they are,
Thank
yes.
you. Moving on. In, again, listening to the evidence of all three of you over the last couple days, I get the impression there's a great deal of movement of staff, certainly at the senior level. And Madame Bombardier, in particular, you have spoken about changes at the senior level. Is the experience of Environment Canada in terms of staff transition out of the norm for the Federal Civil Service, or to the best of your knowledge, what we're seeing with Environment Canada common throughout the Federal Civil Service at the senior level?
I'm sorry, but I cannot comment on that. I don't have knowledge of departmental or government-wide statistics on turnover rates.
Yes, I appreciate that. Staying with you for a moment, are you able to say, in a very condensed sort of way, what kind of staff changes have there been at a senior level at Environment Canada over the last 4 or 5 years that have obviously complicated discharge of duties? You have spoken about that, but what are those changes in staff?
Well, we've had a number of senior officers retire and regional directors.
That have been hired, did you say? I didn't hear what you said.
No, we've had a number of senior officers and regional directors who have retired.
Retired, I'm sorry, yes.
In the past 2 or 3 years, which, you need to bring new people in, and there's a learning curve, so that is a challenge, but with proper training and coaching, it's...
Right, and you took over your current position in May of 2010. So less than a year ago. Can you tell me your predecessor, what was his name or her name?
Renzo Benoshi.
And that individual was in that position for how long?
I believe 8 years.
8 years. In terms of the changes at senior level with Environment Canada, do you have any explanation to give for it other than the fact that there was a series of retirements that you just spoke about? Are there any other problems that have led to such a turnover of staff that you know of?
No, I would say that's the main factor.
Thank you. Mr. Steele, focusing on DFO in your branch, the CNP branch and so on, has there also been a dramatic turnover of staff over the last, let's say, 5-7 years?
No, there hasn't.
Thank you. I want to move briefly to the issue of the relations between DFO and the environment. And Madame Bombardier, you say in your will say, and I'll just put it to you and ask you to adopt it, in part you say under responsibilities of section 35 and 36, I actually read that first sentence of that paragraph a moment ago, and then you said she will say, then the will say says, you will say that in the regions, enforcement officers work closely with DFO and that the strong working relationship appears to be a good one. Nationally, she will say communications between the two departments needs to be reestablished and work is underway to do this, unquote. I assume you adopt that sentence, that is what you want to say?
Yes.
Can you tell us the circumstances that has led to two federal departments having to, quote, reestablish their relations, unquote? What led to such a breakdown or dysfunction in the communication between two federal departments that obviously had great common interest?
I would not say that there hasn't been any interactions. We inform DFO of all of enforcement actions that we take under the Fisheries Act at the national level, so that has been ongoing. What I'm saying, what I meant to say here was that there hasn't been a regular face-to-face discussions, meetings of the two departments, enforcement organizations in the past few years. I cannot speak for my predecessor, but what I can say is since I've been in my position and we have a new chief enforcement officer, we have started the discussions again with DFO to reestablish that those meetings on a more regular basis.
Are the two departments in the same building in Ottawa or the capital region?
No, we are on the Gatineau side, and I believe DFO is on the Ottawa side.
But that, you would agree, should not in any way be an explanation of why there hasn't been or wasn't previously a good dialogue between the two departments?
No.
Obviously. Thank you. We have focused here over the last 2 days in part on what I will call deterrence, issues of prosecution, issues of conviction. And I heard you, Mr. Nelson, speak to the fact that there were many unpaid fines, if I heard the testimony correctly. Did I hear that correctly?
Yes.
Now, I want to explore that for a moment. These are fines that have been imposed by the court pursuant to conviction under Section 35 and 36, or are these fines in some other realm?
They include all outstanding fines levied against Fisheries Act violations, including 35 and 36. Some are ticketable offenses for sport fishing, some are commercial fishing, First Nations, pretty much all types.
So, just in a very rough sort of way, a percentage of those fines would be fines imposed as penalty at sentence in the criminal courts?
Yes. Currently, there's, in this region, just over $1 million in outstanding fines.
$1 million?
Yep.
And can I assume most of these fines are in the range of 5,000 to 10,000 at the most?
There are some larger than that. I would say the average is probably much less than that. But we get a quarterly report that shows us what the outstanding amount is.
the fact that most of these fines are even less than that, can I assume that there are thousands of individuals who have been fined who have failed to pay their fines?
Thousands, again, when I look at the document, I scroll through it, look at the bottom line. Hundreds, could be low thousands. I'm not sure the exact number.
Well, we are talking about, so the record is clear, approximately $1 million of unpaid fines in Pacific region.
Yes.
We are talking about fines imposed of which you say most of them are less than $5,000 or $10,000.
Yeah.
So we can all do the arithmetic. There are a significant number of individuals that have been fined and failed to pay their fine.
Yes.
Can you tell me why that's happening? Is it that there is no follow-up at the governmental end for the collection? Is it a case of the court system not following it up? Where's the problem?
Not exactly sure, but I know we don't have a system to collect and follow up. Do you have any?
Mr. Nelson?
Steve?
I don't have a lot of information to add to that. I know it does come up in discussions from time to time. I know there are issues about the costs that would be involved of us chasing those fines to get collection. There are also some issues around authorities, if I recall. I think there may have been some legal advice to the effect that fishery officers did not have the appropriate authority to execute warrants of committal that would be required to follow through. So there's those issues. Again, the details are a bit fuzzy right now, but there are issues around legal authorities and also getting assistance from other agencies to collect fines on our behalf is not something that is easily done either. I know there's been some difficulties in that area in the past.
Would you agree with me that this circumstance diminishes the deterrent aspect of prosecution? Or more to the point, I'd like to rephrase that question. Would you agree with me that these circumstances diminishes the likelihood of compliance by the public of the provisions of the Fisheries Act?
I would say it has that potential, yes, if it's widely known that that a person could potentially get off without paying a fine, then that could have an effect on compliance and the deterrence level, yes.
And the fact that there are so many people out there who have not paid their fine, surely it becomes known within certain communities that in fact you can get away with this, because if there is to be a prosecution, the governmental agencies are not going to come after you to pay the penalty. Do you agree?
Yes, no, I'm not sure that I would agree to the extent that it's, I'm not sure we can make a blanket statement to say that we would never come after a person for an unpaid fine. I'm sure there are others that were collected through various means that didn't end up on the list Mr. Nelson is referring to. So I don't think it's a case of, anyone at any point in time can evade having to pay a fine, but that possibility is there, and if it's widely known, then that could have an impact, yes.
Mr. Nelson, does this situation frustrate you as an enforcement officer?
I think the fishery officers out there are aware of sometimes this happens, and it certainly is of concern to them in doing their work. Now, it should recognize too that that's a cumulative amount that's been, as long as somebody isn't paying a fine, it's still on record. So I don't know how many dollars worth of fines a year we issued, but we could probably find that out. But it is of concern to officers for sure.
Mr. Commissioner, would it be appropriate to ask of the government that something is filed with this commission that gives a figure that we can rely on with some exactitude, since this $1 million figure is not placed to the which years we're speaking of, or how far back cumulatively it goes? Would it not be in the interest of the commission, and I would request that this information be filed.
I wonder
in
if
due
I can
course.
suggest that we make inquiries through council and see if that's information that can be provided and circulated through Ringtail. At that point, if it is, we can turn our minds to whether and how it might be put in evidence.
I wish to go to my last topic, which is to direct your attention, Mr. Nelson, to your will say, and to page 2. There was a sentence that intrigued me, and maybe it's been covered in the last 2 days, but I didn't hear testimony about it. Under enforcement process, down at the bottom, you say in part, in the second bullet, Mr. Nelson will also explain that decisions to prosecute a habitat case do not rest solely with CNP. In rare instances, political pressures appear to operate so as to redirect investigations or stay prosecutions, unquote. Now, first of all, I assume you will adopt that you are saying that.
Yes, if I am allowed to explain it.
Of course, and I want you to.
Yeah. In my career, there have been a couple of occasions where I was directed to not proceed with habitat prosecution, but they did not come from a politician. They came from a supervisor. In one event, it was an area chief who directed me. In another, it was...
Sorry, in one case, it was a what?
The area... Sorry, they were called district managers back then.
Thank you.
Yeah, district manager directed me not to proceed with the case. And in a second time, before a trial involving a prosecution, I was advised that the charges were being stayed.
But that doesn't speak directly to what you say here in this paragraph, which you adopted a moment ago.
But hang on, this is not a document that the witness wrote. This is a document the Commission Counsel wrote.
One moment. Yes, sorry, you finished? Excuse me. I put to this document, to this witness, whether he adopted this paragraph as being an accurate statement of what he wanted to testify to. He adopted that paragraph.
That's not my recollection of what he said.
I said I'd accept it with explanation.
Yes.
An explanation referring to the word political. I have never had a politician directly influence. I have had occasion where somebody knew an MLA or an MP and they phoned them and phone calls were made. When that information comes back to me, I would direct it to Ottawa. And in no case has there been a political interference with any cases I've been involved in.
So
that I'm aware of anyway. Like the direction I was given, I don't know where it came from.
I appreciate that. Yeah. So in terms of that paragraph, if you would want to correct it by saying that you do not have evidence of political interference. Is that what your testimony is?
Capital P political, right.
What about lowercase p political?
Well, it is somebody directed a charge to be stayed, and I don't know who it is.
And you didn't know why?
I didn't know why.
These are rare occurrences, are you saying?
Yes.
I thank you. I have no further questions.
Thank you. Mr. Commissioner, I have Mr. Harvey for 15 minutes.
Chris Harvey on behalf of the Area G Trollers and the United Fishermen and Allied Workers Union. I'd like to start with this preface. It's the mandate of this commission, as no doubt you all know, to investigate and make findings of fact regarding the causes for the decline of Fraser River sockeye. And I want to ask a general question first. Have you, Mr. Nelson, or any of you, come across anything in your work that you consider to be one of the causes of the decline of the Fraser River sockeye? I'm talking about the decline that started in the late 90s and continued through to 2009. I think probably Mr. Nelson would be in the best position to answer that question.
Just to get it clear, you want to know, going back to the 90s forward, is what do I think might be some of the causes to declines?
Yes, from your area of expertise and your experience.
From where I sit, and what I've seen throughout my career, everybody has done a part. I mean, anybody who points the finger has got to also look in the mirror. And commercial fishermen are responsible for some. All user groups, recreational fishers, First Nations, everybody who lives along the water, who has waterfront property, is impacting in some small way. I mean, everything we do impacts it. So, as far as, I think everybody has played a part in it. At times, one user group will appear to have more of an impact than others. It's really a difficult question. There's no, in my view, there's no magical formula to come up with what's happened to fish. Environmental changes have no doubt contributed to some of the things as well. There's things we don't have control over. Logging, back in get the decade right, but 70s or 80s, there was massive logging of in the Upper Fraser watershed that exposed huge areas of area, which increased runoff. So you can look anywhere in the province, anywhere in the watershed, and people will have had an influence.
You mentioned that your budget had been increased following the Williams inquiry, I think it was.
That's correct.
What was identified in that inquiry that led to an increase in your budget? I gather it was for increased fisheries officers.
Increased enforcement on the Fraser River, particularly, to closed area patrols and throughout the watershed. That's where the money was put towards. It went towards helicopter flying, increased operational money, increased overtime, and those are the main things. And over that was in 2005, and up until the last number of years, it's more related to the fisheries enforcement and the things at Habitat, because over that same time period, our habitat enforcement has dropped.
I expect we can look in the Williams report to see what it was that led the government to, or led to a recommendation for increased funding.
Yeah, the recommendations are there.
Yes, all right. And you mentioned, I think, the prospect of losing 30 or 40 fishery officers now as a result of the sunset provisions in the PICFI program. Have I got that right?
It's an accumulation of the potential for those programs to sunset and the existing salary dollar shortfall that we're under. The two combined.
How would losing 30 or 40 fishery officers impact on your efforts with respect to Fraser River sockeye?
Well, if you just a straight math formula, 30 or 40% is 20-25% of our fishery officer complement throughout the region. So it could impact it by that much. And we have a lot of offices who have 2 officers present, and if we stop hiring and one of those officers moves on, that office has effectively not able to conduct patrols without somebody traveling a long distance to join them. So it accumulates. It causes more money to be spent on travel, etc. So the actual impact would probably be greater than 20 or 25%.
Yes. And is it in particular the migratory route of the sockeye salmon that you're considering when you talk about patrols in the sockeye context?
Yes, I mean the sockeye travel all the way down from the north coast through south coast, BC Interior, Lower Fraser. The only area not impacted is the Yukon.
I didn't understand this, and perhaps you can explain it. What is the logic that resulted in the transfer of that money you got, the budget allocation you got as a result of the Williams report, transferring that into PICFI?
What was the logic of it?
Yes, yes, if there is a logic.
I don't know. I personally spoke out that I thought the Williams money should be A-based, but it was rolled into PICFI, which is sunsetting money, and next year we're here.
PICFI, part of when I was trying to answer that question for myself, the one thing that occurred to me is that part of the PIC fee program is designed to establish commercial fishing upriver.
Correct.
And that, I suppose, requires more enforcement action
Well-
and monitoring, does it?
Well, the Williams money was more focused on patrolling close time. PIC fee was more to move towards integrated commercial fisheries. So I just thought it's not really a good fit. They should have been kept separate and funded separately.
Once you go from food fishing to commercial fishing in the river, does that give rise for a need for more surveillance and enforcement?
It changes the way we do enforcement. It would have some additional complexities that, if you have a commercial fishery and a First Nations fishery simultaneously, it creates extra tasks for us to do, yeah.
Yes.
And I guess affecting habitat, of course, all of that during our summer months when it is peak salmon migration time, we don't have as much time to put attention towards habitat enforcement on the Fraser River.
Yes. Now, on the question of habitat, you discussed the no net loss policy. With respect to sockeye habitat, it's really the quality of the spawning areas and the rearing lakes that's the critically important thing, is it not?
Yes.
Yes. In the sense of maintaining the productivity of both the spawning grounds and the rearing lakes.
Yes, and migration routes all along, and estuaries. The Fraser River estuary is a key vital thing as well.
Yes. In terms of productivity, I recall that it hasn't happened here, fortunately, but Lake Erie in the 60s was said to have become a dead lake, I think, through the result of all the effect of population, nutrient additions to the lake as a result of human activity.
I'm not aware of that, but
But that's the sort of thing you focus on, isn't it, when you're dealing with habitat concerns and habitat protection of the rearing lakes?
you're concerned with the whole range of things that could impact the fish habitat. Shoreline, vegetation, spawning grounds, deleterious substances entering the streams, people catching fish, people operating boats in rivers where fish are spawning. There's so many ways that it can be impacted.
Do you liaise with the biologists who have the expertise with respect to what is essential to maintain the productivity of a rearing lake, whether it be the cultus or the Shuswap or?
Our officers are usually graduates, many with university degrees, have a lot of that knowledge already. On-the-job training, they receive a lot of that as well. And then working closely with other program staff, they work with our biologists as well, yes.
Now, we've heard evidence here that the cultus is a kind of a bottleneck in the sense that the cultus stocks are stocks of concern, and it's affecting the economic returns in the wider commercial fishery. And we've heard evidence that starting in about the 70s, productivity of the cultus seemed to drop and a cyclic pattern developed with the fish. I'm wondering if the human activity around that lake has engaged the attention of your section.
I've never worked in the Lower Fraser area. I'm familiar with the weakness of the Cultus Lake stocks, but I'd be reluctant to comment on an area I haven't worked. I could say that in areas where I have worked, in the interior. Certainly, I know of one small lake in the Quesnel area which had a very large number of people living around it, and it was on the verge of becoming eutrophic through all the increased septic field inflow into the system. It wasn't a salmon stream or salmon lake, but Shuswap Lake is another example of one I'm more familiar with. All of the foreshore development and septic inflows into that lake are having an impact.
Yes. Eutrophic is that results from
too many nutrients,
yeah.
and the lake essentially dies.
Yes, I think that's what I was trying to get to in the Lake Erie example. Do you consider that you have sufficient powers under the Fisheries Act to deal with that, in the sense of, I think it's called anthropogenic nutrient loading? In other words, one example would be failed septic systems that you mentioned. Do you have sufficient powers to deal with that?
It really is a Environment Canada matter when it comes to an effluent like that, and it's licensed by the province. The province also has some jurisdiction over whether you can put a septic field in, and regional districts. It's a little bit beyond my expertise.
But if it's resulting in a lake becoming eutrophic, and that lake is an essential sockeye rearing lake, would that not engage the attention of your section?
If it were identified to us of violations, yes, it would.
What would it take to identify it to you?
Well, I'm not sure where you're going or what you want. As far as the Shuswap Lake system, I'm not in any way inferring that it's on the verge of becoming eutrophic in any way. It has a very high turnover rate. It's
Yes.
extremely fast turnover and inflows, so that's not an issue in that lake.
And the cultus, you're not.
I'm not familiar with cultus.
Well, let's use the Shuswap example then. If you considered, or if biologists in the DFO considered that the nutrient loading was becoming a problem and was affecting the productivity of that lake system, would you be able to deal with it?
I think that our biologists, habitat staff are trying to work with municipalities and cities and regional districts to try help develop the guidelines so that people know what the rules are in discharging into lakes. And if somebody were to breach those rules and it results in harmful alteration of fish habitat or something like that, then we could become involved.
Yes. Okay. Those are my questions. Thank you.
Chris Buchanan, counsel for the PSAC. I just have a couple of questions of Mr. Nelson. I gather from your testimony yesterday that your view is that one of the best tools of enforcement is the feet on the ground.
Yes, officer presence, I said, is one of the key tools.
And I gather from your evidence yesterday there's been a decline in the amount of enforcement that your officers are able to accomplish since 2005. Is that fair to say?
Yes, following the direction that came to us to reduce habitat enforcement work, there is less of it going on, yes.
So my question to you is, how many additional pairs of feet would be necessary today to meet the same level of enforcement as there was in 2005?
Well, as I said, with the budget conditions we're expecting to be under, the number of 30 to 40 is a ballpark estimate of what I thought we would need funding for. As far as additional, that would fund our existing. I'd have to give some more thought to what, I mean, at the peak of fishery officer numbers, we are at a number of 212. I don't remember when that was. It was quite a while ago.
So, and if you need more time, is it fair to say that you would view there to be 30 to 4 additional officers to reach the same level of enforcement as there was in 2005?
No. The funding shortfalls that we anticipate we could be at as of April 2012 are in the range of $4 to $5 million. that would keep us at the levels that we were at in 2005. Now, we would have to have a change in priorities from the government to return to do the amount of habitat enforcement we were doing. But during that time, there have been a whole lot of other duties that have been added to our portfolio. So how would I measure those? I'd have to do a little more math.
Well, that's my last question. Maybe appropriate if the witness needs a little time to think about that over the break, and maybe he can return with an answer to that. Is that, if that's fair?
Yes, I think it's fair. If he thinks it's fair, he may need more time than just a break, Mr. Buchanan.
Well, if
Maybe Mr. Buchanan could just restate the question so that Mr. Nelson knows exactly what he's considering.
Well, let me just say that I've been having trouble following this because there's a number of numbers being kicked around. So perhaps if he gets the break, you're taking him back to 2005, is that correct?
That's correct, and I'll try to rephrase the question so it's clearer to everybody involved. Setting aside the announced budget cuts that would reduce the capacity of your department, so just taking the existing complement now.
I hate to interrupt again, but there's no announcement of budget cuts. I'm not sure what he's referring to, or what Mr. Buchanan's referring to.
Well, I believe...
There's a sunsetting program. There's been a lot of evidence on it.
Well, with the reduction of resources allocated to your department, whether it's styled as a budget cut or a non-renewal of the funding, setting that aside, just speaking with respect to the officers present now, how many additional officers would there be needed? How many pairs of feet would there be needed to reach the same level of enforcement as there was in 2005? Now, you've indicated there's additional duties upon your officers, so taking that into account, how many more officers would you need just to meet the enforcement of 2005?
I wouldn't be able to answer that in a few minutes' thoughts either. It would require a little. I have some information that I could provide, but it wouldn't be today.
But perhaps what we can do is, with respect to some witnesses, we've asked them to follow up their answers by way of affidavits and/or will say statements. Perhaps I can talk to counsel about giving this witness that opportunity. Thank you.
We'll certainly have that conversation. Thank you. Perhaps we'll move to break then?
Yes, we'll move to break for 10 minutes, and then Ms. Brown, you have until 4 o'clock or I think you might. Do you have any more questions you're going to have?
None from Commission Council at this juncture. I don't know if Mr. Taylor would seek to re-examine on any points. Maybe too early to say.
Well, of course, I can't speak to Ms. Brown's questions. One, I think.
Well, Ms. Brown, if you could keep that in mind, because we will be adjourning at 4.
Mr. Commissioner, I can advise that I don't expect I'll require the full hour.
All right. Thank you very much.
I'll recess for 10 minutes.